the former Supreme Court Justice Adolfo Azcuna opined that surrender must be made pursuant to an applicable treaty. And since the Philippines is no longer a party to the Rome Statute, what then is the applicable treaty? Wala nang treaty. Dahil ang ini-invoke nga yung Rome Statute, wala na ngayon. Siguro si Justice Azcuna mas mahusay magpaliwanag.
Thank you very much, Madam Chair. Regarding the applicable provisions, the justification given by government for the surrender of former President Rodrigo Duterte to the ICC consists of two grounds. One is the warrant of arrest issued by the ICC and served through the protocol of the Interpol. The other is Section 17 of Republic Act 9851, which is the Philippine IHL law, and which provides that if a person is already being investigated for the crimes covered by this act, which includes crimes against, which includes the crimes for which President Duterte is being charged, is already being investigated by an international tribunal. The relevant Philippine authorities may surrender such person to the international tribunal, but it adds pursuant to the applicable extradition laws and treaties. Ngayon, ang tanong, ito bang last sentence na ito, which provides for the requirement that the surrender should be pursuant to applicable treaties, is still applicable since we don't have anymore the Rome Statute. Sa palagay ko po ay it's either we have the Rome Statute or not. If we don't have a treaty, then we cannot surrender the suspect to the ICC under this section, because this section requires that the surrender be pursuant to a treaty. Pursuant means in accordance with. And so if there is no treaty, in my view, we cannot make a surrender. On the other hand, if there is still a treaty that is due to the residual obligations that the Philippines may have even after withdrawal, pursuant to Article 127, Paragraph 2 of the Rome Statute, after withdrawal, the withdrawing state still obliged to cooperate with the ICC in relation to matters already under consideration by the court prior to withdrawal. So it again, you go back to the question, is the Philippine situation something already under consideration by the court, by the ICC, prior to our withdrawal? In my view, Madam Chair, the answer is yes, because as of February 8, 2018, prior to our withdrawal, Fatu Bensouda, the former ICC prosecutor, already said that the Philippine situation is under preliminary examination as of that date. The question is whether or not the prosecutor is the court, because 127 paragraph 2 says under consideration by the court. And in my view, it is, because there are four principal organs of the ICC. The first is the presidencies. There's one president and two vice presidents. The second are the judicial divisions. The third is the office of the prosecutor. And the fourth is the registrar. So the office of the prosecutor is part of the court. Therefore, when Article 127, Paragraph 2 says the matter must be under consideration by the court at the time before withdrawal, it includes consideration by the prosecutor. And so therefore, I believe we have residual obligations even after withdrawal. Question therefore is whether or not the warrant of arrest issued by the ICC after our withdrawal is something we have to cooperate with under 127 paragraph 2. In my view, yes. And therefore, in my view, the warrant of arrest is legal. However, I believe that the surrender is not, because the surrender must be pursuant to a treaty, and therefore our own law, Section 17 of Republic Act 9851, brought back the Statute of Rome, even after withdrawal, because it requires that a surrender must be pursuant to the applicable treaty. And therefore, in this case, the applicable treaty remains the Statute of Rome. And thus, we have to follow Article 59 of the Statute of Rome, which requires that the custodial state, namely the Philippines, must first bring the arrested person to a local court to determine two things: whether or not the person is really the one named in the warrant; second, whether or not the person has been informed of the charges against him or her. This was not done. Therefore, there was, in my view, a violation in the act of surrender. However, Madam Chair, this is in the forum of the Philippines, but in the forum of the ICC, different rules apply. The rule in international law, Madam Chair, is that procedural laws are governed by the forum. So procedural safeguards are applicable only to the forum. If the Philippine Bill of Rights, for instance, which says that no person however, criminal proceedings before the ICC is governed by their own procedure. This is in accordance with private international law, that procedures governed by Lex Fori, the law of the forum. And therefore, we go to the procedure in the ICC. In the ICC, I believe they follow what is called mali coptus beni detentus, meaning that even if the arrest is illegal, the detention can be legal. It does not automatically mean that if the arrest was illegal, the person arrested must be released. They will balance, it's a balancing act. They will balance the illegality of the arrest with the need to prosecute someone for very serious offenses under international law. And in their view, the balance weighs in favor of prosecution. They will prosecute, notwithstanding the violation of the procedure in the arrest and in the surrender, I mean. Therefore, it depends on whether you're talking about Philippine Forum or the ICC. The ICC, I believe, will follow their own procedure, whereas in the Philippines, as it is now pending in the Philippine Supreme Court, in my view, there is a violation and there will be consequences for that violation. Thank you, Madam Chair.